California Evidence Code Division 9. Evidence affected or excluded by extrinsic policy. Definitions. But Section 1107. Admissibility of battered women's syndrome evidence. Section 1109. Evidence of defendant's commission of other acts of domestic violence. Here's something. As used in this section, quote, abuse of an elder or dependent person means physical or sexual abuse, neglect, financial abuse, abandonment, isolation, abduction, or other treatment that results in physical harm, pain, or mental suffering, the deprivation of care by a caregiver, or other deprivation by a custodian or provider of goods or services that are necessary to avoid physical harm or mental suffering. Here's another one. Evidence of acts occurring more than 10 years before the charged offense is inadmissible under this section unless the court determines that the admission of this evidence is in the interest of justice. Well, let me ask you a question. If you try to proceed in a case in order to obtain due process and they force you on the streets for 3 years, or rather 2 years while you're actively trying to go through the court, and then they allow you inside only to be remanded to nothing more than conversation with one person that compulsively lies to them, while their entire life and everything about their identity is allowed to be harvested out of them. Do you not think that that would be a just consideration of mental suffering, of financial abuse, of isolation, of deprivation of care, of abduction? Let me ask you a question. If somebody's gainfully employed and has enough money for a down payment on a house, but is refused even to be able to acquire a lease in their name because it's later discovered that somebody took out a lease on them as their real property in a mineral interest claim, and so they can be subjected to all of those other forms of abuse in complete denial of due process. Does that qualify? I mean, by the letter of the law, it qualifies. By the letter of your law, it qualifies. Let me ask you a question. Why was I not allowed to receive my own pension benefits? Why did you create some facade that somehow in your specific model of rehabilitation of people, you in your professional capacity identified as being mentally disabled and hence available for some form of rehabilitation, including through gainful employment in a civil service position, when the time came for me to leave and you would have judged that I had earned pension benefits and issued a check, why did I not get it? Why was I not even allowed to have acknowledgement that you had done that in my name and with my identity? Why was there no assistance with saying information about the alleged employment that I had with your organization under the alleged context has been misrepresented for years? When are you going to do something? And it's been more than 5 years, and that 10 years has passed. Did you intentionally refuse to respond, hoping that you could pass the 10-year mark? And then in so doing, what? Because if I'm not incorrect, we're coming up on what would be 6 months after the 10-year anniversary of when I was presumably provided with legal representation that told me I was eligible for back payment on lost wages. But we weren't talking about wages. We were talking about equity. And you lied.